You cannot wing it walking to federal court. You can't pick up a file in the hallway. I'm going to run in and handle your federal cocaine conspiracy. And then what is a probation case in state court becomes a 5-year mandatory minimum in federal court, a 10-year mandatory minimum in federal court. Hi, I'm Lana with Rawson Law Firm. We're a criminal and DUI firm in South Florida. And in today's video, I'm going to be talking about what makes a case a federal case, what makes a criminal case go federal, so to speak. And if you haven't already subscribed to our channel, please subscribe, because the Rawson Law Firm posts informational videos, client testimonials, and other very useful videos we think would be of great use to you if you or a loved one are facing any kind of criminal charge in South Florida or even elsewhere. We want to be your go-to source for information like this. So let's get to it. How does a criminal matter become a quote-unquote federal case, or go federal, as people say? I think there's a lot of misconceptions about how this takes place. I've heard people say things like, well, if you cross state lines, your case will go federal. If I sell drugs but I don't leave the state with the drugs, it can't go federal. The crossing state lines is a complete myth with respect to how something comes under federal jurisdiction or not. Basically, the federal government has the authority to pass and enforce laws that affect interstate commerce. And this is an extremely broad category of activity. And what that means is almost anything can be a federal case, or almost anything criminal could be prosecuted federally. Because, for example, if you possess a firearm, unless that firearm was made in the state where you possess it. So unless the firearm that you possess illegally was made in the state where you are at the time, you are committing an act that affects interstate commerce, because that firearm has traveled in interstate commerce. Drugs, cocaine, marijuana, unless you grew the coca plant and formulated the cocaine, and all of the additives into the cocaine came from the state that you are in, you are affecting interstate commerce. I mean, these are sort of the most common examples, but even broader than that is wire fraud. Almost every fraud that is committed in the modern day involves an email, an online application, a text message, a phone call, you name it. Even if it's a fax, an old school fax, you are utilizing wire communication. And if you are engaging in any kind of fraudulent activity, and anywhere along the way you're using wire communication, or your cell phone, for instance, then you are committing wire fraud. And so you can see that almost any activity that's criminal could fall under this interstate commerce clause that allows the federal government to step in. So really the more important question than how does a case go federal is why does a case go federal? Because obviously if the federal government can prosecute almost anything federally, why don't they? And they obviously don't. Our state courts are obviously very busy, and not all drug cases, not all kidnapping cases, not all violent crimes, not all frauds are prosecuted by the federal government. Normally, if the case is going to go federal, it has some aspect to it that is of particular interest to the federal government. That could mean that it's a hot button issue. For instance, fentanyl. Fentanyl is the drug of the moment, and not to make it seem glamorous, because it's quite the opposite. But every few years, there's a new drug that is the the biggest scourge on the community. In the 80s and 90s, it was crack cocaine. Then in the early 2000s and 2010s, ecstasy was a very seriously prosecuted and heavily prosecuted. Methamphetamine, crystal meth was a big problem and came into play as a target of the DEA and federal prosecution. And today it's fentanyl. So whereas you may be arrested by a state officer for possession of fentanyl, if the quantities are large enough, or if you have information, for instance, about somebody who's selling large quantities, your case might go federal so that pressure can be put on you to talk about the folks that are higher up in what eventually would be charged as a conspiracy. Because right now, the federal government is very actively trying to battle fentanyl. Other examples are types of fraud. Fraud against the elderly right now is a hot topic for law enforcement in certain areas of the country, especially South Florida, where we have a large population of older citizens. This is a huge problem, and more frauds that are targeting older citizens, using the fact that they're not as tech savvy as some of the younger folks, for example, or involving healthcare or construction on their homes. That is something that is really heavily being targeted by the federal government now for enforcement. So those types of offenses, which could be something very localized and happening, they appear to be small, might go federal because it is something that the federal government really has a significant interest in right now. Other times it has to do with a particular administration's positions that they've taken during a campaign. The Justice Department is part of the executive branch. The Attorney General of the United States is an appointment by the president. And so if someone runs for office on a stance that they're going to go after a particular kind of criminal offender or a particular type of criminal offense, then you're going to see in the years that follow more and more prosecutions of those kinds of offenses in the federal courts as opposed to the state courts. And so, what does this mean to the defendant? This means that you're going to be, if your case is prosecuted federally, you're going to be prosecuted by a body, by an entity with basically limitless resources. When your case is brought, it will not be brought because a local police officer pulled you over on the side of the road and found a bag of drugs in your car. It will be because after that traffic stop, you were let go, and then an investigation began involving one or more federal agencies, and a case grew and grew and was built on extremely solid ground. And so you're facing maybe the same charge that you would have faced in state court, but with a much more solid footing for the prosecuting body, which in this case is going to be the United States government instead of your local county government. By the time that you find out you're charged in federal court, and, let me clarify, I'm talking about serious felonies, not misdemeanors that, might occur on federal property or something like that. Most federal cases are felonies, so I'm talking about serious cases. If you find yourself charged federally, chances are the federal government has built a case through an investigation against you. They have likely already turned some folks, we say state's evidence, and you'll see that on TV, but, they've turned some folks into cooperators. People are already talking about you behind the scenes to try to keep themselves out of trouble. And you are looking at fighting, as I said, a law enforcement and prosecutorial body with limitless resources, a budget that's really unimaginable to somebody who has to come up with money to hire a lawyer to represent them against this entity. That's why hiring a criminal defense attorney with federal court experience is crucial. The best state defense attorney if they do not go to federal court, is not the person to hire for a federal case. It's a completely different animal. The standard of the federal judge, what is expected of an attorney when they walk into a federal courtroom, is much, much, much higher than what is expected when you walk into a state courtroom. State courtrooms are busier. There might be 100 cases on the docket that morning. The idea is to get through things quickly. Deals are made quickly. Investigations aren't very long. And it's just a different animal. I mean, obviously, it's very important to have an excellent attorney no matter where you go, but you want to have an excellent federal attorney if you're going into federal court, because when you walk into that courtroom, in a federal courtroom, your case might be the only one on the docket. That judge has read every single word, potentially hundreds of pages, regarding your case, and is expecting your attorney to be absolutely on the ball, to be ready to defend you with knowledge of case law, with knowledge of all the facts of your case, with a full understanding of where the case is headed, where it should be headed, all of the possible consequences that you're facing. It will be expected that you've been advised of every single direction this case might go, and what the end of that road, of each of those roads, might look like. And it's frankly not for the faint of heart on the attorney side. I've practiced in federal court now for 26 years. I've been an attorney for 26 years. Most of my peers who are of my age did not start going to federal court, if at all, for 10 to 15 years into their practice. It's an intimidating thing. And if you are speaking to an attorney because you have a federal case, please make sure that they regularly appear in federal court, and ideally regularly appear in the federal court that you're charged in. But I will tell you, it's more important that they have federal experience than that they have experience in your federal court. You don't want to go with anybody who doesn't appear in federal court and says, oh, well, I'm always in the courthouse down the street from the federal court, in the county courthouse. I'm there every day. That's great. If you have a county case, that's a fantastic option, possibly. But federal experience is really, really important, because, and this will be the subject of another video, the way that cases are prosecuted is often a multi-defendant type of situation, a conspiracy. I mentioned that cooperators are often already floating around in the background by the time you find out you're even in trouble. And, navigating this system that is built on cooperator testimony, that is prosecuted with, limitless resources and highly skilled prosecutors who are able to focus on your case and don't have 100 cases on their docket. They are really focused on you as the defendant when you're charged in a drug conspiracy. That's something that only a federal attorney really will know how to do. The sentencing guidelines, they are complicated. They are advisory. They're not mandatory, but they are a potential minefield if you have an attorney who is not familiar with the pitfalls and also the few and far between beneficial parts of the United States sentencing guidelines. You have to have someone who knows how to capitalize on what's in there that's favorable for defendants and distinguish your case from the many, many unfavorable enhancements and provisions that can increase a defendant's exposure under those guidelines. You have to have someone who knows what judges still abide by the guidelines and which judges are happy to depart downward or upward, as the case may be. You have to have someone who really knows how to research federal cases, which is a little bit of a different animal than researching state cases. You can expand your research in federal court, certainly within the circuit, but sometimes to other circuits, but you have to be picky. You can't cite, for instance, in the Fourth Circuit, you don't want to cite to the Ninth Circuit. These circuits don't agree with each other on anything. And so it's fairly useless to come in and say, I have this great case from the Ninth Circuit, if you're in a court in the 11th or the 5th or the Fourth Circuit. And so all of these little idiosyncrasies, and honestly, I could go on for days about them. These are the things that you have to make sure that your counsel is aware of. Even if they just don't know what they don't know about your particular case and your particular judge, for instance, if it's a newly appointed judge, a federal defense attorney with experience will know what they have to do to make sure that you have the best footing when they walk into that courtroom. And frankly, because the standard is so much higher and the expectations are higher of counsel in federal court, there's a little bit of an ego thing involved, right? That your lawyer should want to make sure that they look good in front of the judge, as well as making you look good in front of the judge. And a good federal, an experienced federal defense attorney will know that that takes work. That cannot be, you cannot wing it. Walking to federal court. You can't pick up a file in the hallway and say, oh, I did 100 of these today. I'm going to run in and handle your federal cocaine conspiracy. There's real preparation, and, the stakes are extraordinarily high in federal court. Again, this will probably be the topic of an entirely separate video, but why are the stakes so high? There are a lot of mandatory minimums that come into play on the most common federal offenses. And so, you can have a street level drug dealer who in state court would absolutely get probation for the quantity of drugs that they have on their person when they get caught. However, in federal court, if they are considered part of a drug conspiracy, which everybody, as I said, unless they are producing, packaging, cutting, and selling all only their own supply that they made from scratch from day one, every single person along the chain of supply and sale and everything, introducing people, everybody's part of a drug conspiracy. So the same street level dealer who in a state court for selling a few grams might get probation, if they're charged as part of the conspiracy in federal court, the entire quantity that the entire conspiracy is responsible for distributing, which could be across international borders, state borders, town borders. It could just be at every club in Miami. Okay, we're talking, it could be hundreds to thousands to tens of thousands of times what that individual street dealer had in his or her possession. And then what is a probation case in state court becomes a 5-year mandatory minimum in federal court, a 10-year mandatory minimum in federal court. And so, the stakes are really astronomically higher. These are life-changing charges in federal court, whereas in state court, there could be diversion in state court on a case of just possession of cocaine. So, I can't stress enough that you really want to have a team on your side, like we have here at Ross & Law Firm, of attorneys who get it and who don't take lightly how serious, a federal charge is, both for the defendant and for an attorney who's going to undertake to take on that representation. It's an awesome responsibility, and you want to have attorneys that really relish taking on that kind of responsibility. They're ready for it, they love it, and they really sink their teeth into what is a really meaty case and needs really constant and undivided attention. We can provide that for you here at the Ross & Law Firm, and we hope that this has been somewhat informative, and I definitely encourage you to watch our other videos related to federal and state law. I'll be providing some videos on conspiracy, expanding on the idea of conspiracy, talking about cooperators and substantial assistance and how that helps people get out of these awesome mandatory minimums, but why it is a system built basically on snitch testimony, and other sort of war stories that I have over the last 26 years, some more notable and interesting federal trials that I've been a part of, and some successes and some failures that have come along the way that have taught me a lot about what it takes to help people in these really serious situations.